One.
Hello, everyone. I'm Don Bautista, the Executive Director of AC Friends of Court. We assist British Columbians in completing their legal forms. And we designed this series of interviews with the heads of courts and the chairs of different tribunals in our province to provide them an opportunity to speak to you directly. What we noticed, of course, was when we do our client intake, and we've been doing this for the last 2 months during COVID, is the palpable increase in the stress that the average British Columbian is feeling when they reach out to us for help. So what I'm hoping to be able to do today is to allow our guests to inform you, the public, what they've been planning and the thinking behind the planning that's gone on. Secondly, to tell you directly how they are working to even the playing field, in as much as in the case of the provincial court, as Chief Judge Gillespie will say, there's a significant number of self-represented litigants that appear before them. The third is to share their reflections on what they are learning now that pandemic's been with us for 2 months. So our guest today is the Chief Judge of the Provincial Court, Melissa Gillespie. Thank you for agreeing to appear before us through Zoom so that you can talk to the public and you can tell them what you've been up to, assure them that things will be all right, and you know that the public can still participate in front of your courts even though they cannot have a lawyer next to them. So Chief Judge Gillespie.
Good morning, Dom. Thank you for providing me with this opportunity to speak with you and the people of British Columbia about what the provincial court has been doing over the last several months to address the issues that have arisen in the justice sector as a result of COVID-19. We are certainly in an unprecedented situation in terms of the challenges that the justice system has faced as a result of the worldwide pandemic. There is no question that courts all over the world are experiencing disruption in terms of their ability to keep the public safe, provide access to justice, and ensure that the rule of law is accessible and available to citizens, notwithstanding this unprecedented pandemic situation. Different jurisdictions are responding in some ways differently, but I do find strangely some comfort as I look at the other courts across the world and the way in which they are also coping with this situation in terms of the innovations that they are undertaking. They're very similar to the innovations that our court is also looking at undertaking and continuing to undertake in order to ensure there is access to justice for people in British Columbia. The BC Provincial Court is certainly known, I think, in British Columbia as the People's Court, in the sense that it serves the vast majority of people in British Columbia who have legal issues that bring them to court. I know that you are in the process as well of interviewing the other Chief Justices in the province, and their courts as well are fundamental pillars in terms of our democracy and access to justice. In addition to that, there are a number of tribunals who service the public, and indeed they are also often the front line in terms of the place where people in British Columbia come to resolve some of their legal disputes. I must say that we have had an unprecedented level of collaboration amongst the courts, but also amongst many of our stakeholders in the last 2 months as we have come together to try to develop solutions that will be both enduring but also capable of meeting the needs of, and very different needs of, many different people in BC as they come to our courts. I recognize in part that one of the issues the virus has presented is that it makes it very difficult for there to be in-person hearings at the moment. That, of course, is because there is an acute need to enforce physical distancing and to stop large numbers of people from congregating. the people of British Columbia have come together and united in that front. And as a consequence, we now see some of the restrictions in our community being lessened. And we as the courts are beginning to respond to that, as are others in the community, on the basis that there is still an ongoing need to recognize that businesses and the public are beginning to come back to work, but there's still an ongoing need to ensure that the public is safe in doing that. And the need to physically distance has not gone away, and that is because the virus is still there. There is no treatment and no present vaccine. So we are beginning to develop procedures to manage our systems in light of that. So what I would say is that we are developing means in which we can hopefully provide ongoing access for people who have all kinds of capabilities relating to technology. There is, I think, I've heard it described as a digital divide. Some people have complete access to technology and are very comfortable, and not only have access to technology in the sense that they have computers with cameras, but they also have access to internet and or data plans that certainly facilitate their ability to engage in the way that Dom and I are today. But there are also many people in British Columbia who, while they may possess some hardware, they might have a smartphone, they may have a laptop, but it may not have a camera. In addition to that, even if they have that equipment, they may not have access to a data plan or reliable internet. There are many communities in British Columbia who do not have reliable internet service. That's something sometimes it's hard for many of us in larger centers to contemplate, but even recently, as we've witnessed a number of places that historically have offered free internet services, like many coffee shops, for example, as they've closed, people's access to internet has actually been more challenging too. So the provincial court needs to develop a number of different ways to interface with the public so that we can continue to provide access to justice. And that's precisely what it is that we are endeavoring to do as we manage this court through this crisis, which is developing all kinds of different interfaces for members of the public who may have differing capacities and abilities to access the court. And so, for example, for those who do have the benefit of this technology and do have accessible internet plans, we are working to develop a process for online hearings, online conferencing to assist those individuals. And for those who do not, we are working hard to recover some of our court operations so that we can accommodate those people either through audio telephone hearings, which we have been conducting over the last 2 months, or through some form of in-person court hearing when we are able to do that. Presently, we have been conducting urgent hearings. That's where we first started. We reduced our operations to the level of urgent hearings, and most of those were done by way of telephone or audio conferencing, and also to some extent through the use of written submissions and written materials. But as we've progressed further, we've issued several new updated notices to the profession. And indeed, we've been recovering quite a bit of our work using other means apart from physical attendance at courtrooms in our case conferencing. Generally, right now in our case conferencing in small claims and our family and child protection matters, those case conferences are really commencing. They began last week. They're really ramping up this week. And we are recovering all of the case conferences that we lost as a result of COVID period number 1, which was between March 15th and May 16th. And then we will work to recover the second group, which is between May 19th and July the 3rd, so that we are able to provide case conferences on all of those matters. In addition to that, we are working on recovering the trials that had to be adjourned by contacting individuals to create pretrial conferencing opportunities on those matters to identify what the issues are, whether there are available admissions, and the extent to which we can use technology in those matters for the hearings that may be coming after that. So we are equipping our judges essentially with a number of questions to ask people when they are conducting case conferences. And those questions include whether or not the litigants have access to computers with cameras, access to internet, access to data plan, and then questions around what the litigation looks like in terms of complexity, whether there are a lot of witnesses, do those witnesses have access to computers and this form of technology, and are there, for example, a number of exhibits. We're also developing mechanisms in which people can get those exhibits or pieces of information to the court in advance of settlement conferences so that the judges can more fully understand what the cases are about. So we're working hard, Dom, to continue to provide services to the people of British Columbia in a variety of different ways. Our goal really is to assess what the needs of our litigants are and what their capabilities are in terms of technology, and then to offer a hearing for them when we are able to fully introduce this technology so that they can have a hearing using this technology if that's available to them. And if not, we will work to develop whether or not the hearing can proceed by way of telephone or audio technology, or whether it can proceed in part that way, in part with some written materials, or whether it requires all of the parties or some of the parties to come to court. In addition, of course, the efforts in case conferencing is always to case manage, but before the case management, to see whether or not there can be a mediated resolution to that dispute. And so that is also being pursued. Because we're doing all of these initially by telephone, we've allowed greater time for those hearings. So rather than having typically 5 or 6 of those scheduled in a day, now a judge will hear 3 of those. So it allows them the opportunity to really spend some time with the people to understand what the related issues are. I would also just say that there's a lot of really good information on our website, and would really direct people to the British Columbia Provincial Court website. There's some information on there about, for example, what to expect in telephone hearings, what to expect in a video hearing, what are some of the things that you can do as a litigant to prepare yourself for that, and how to organize yourself as best as you can in terms of providing yourself with as quiet an environment as possible so that you're able to fully focus and concentrate on the pretrial conference or the family case conference or settlement conference as it may be. So we're really making efforts to provide as much materials to the public as possible to assist them, because it's not only new for us, it's new for them. And we want to make this as accessible an experience as possible. To that end, I will just say that our website page views have gone up tremendously. In January, for example, there were approximately 110,000. In February, there were around 100,000. In March, there were 168,000 page views. And in April, we were coming back around to about 112,000. So up a bit, but March, we certainly saw a tremendous amount of traffic. We also are continuing to post our e-news articles, which generally speaking provide a lot of interesting information about the provincial court, but also more recently, I think are providing quite a bit of information for litigants about what to expect when coming to court in these COVID times. So I would really encourage people as well to subscribe to that and to continue to consult our webpage. And I will also just say that we've published a guide to Microsoft Teams, which is the technology that we're using to assist in terms of video hearings. We're not quite there yet, but we're moving as quickly as we can to offer those types of hearings. And as I indicated before, gathering the information that we can about people's capacities so we can offer that where that is possible. And there is a guide that we've also put out in NP21 that's on our website that attaches as an appendix a guide to using Microsoft Teams. And I would strongly suggest that people review that if they're going to be using that technology when they come to court. Anyway, Dom, I know you wanted to ask me some questions, and I've been talking a lot, so over to you.
Well, you know, the old model that the courts, the judges in particular, are not seen and unheard. I think that's gone out of the door very quickly because of pandemic. And I by no means was going to rush you. I'm enjoying hearing you speak to the public directly, unfiltered, no media in between except just the camera. So thank you for that, Judge Gillespie. 2 months may be a short time to be asking this, but and I'm not really concerned about the minutiae of a lot of things, but sort of the big picture. What have you and your staff, what have you guys been doing to sort of look at how you can better carry out your responsibilities to the public? I will say that the ethos, the provincial court, in terms of innovation, is remarkable. And I'm not talking about just technology. Sport person guidelines, for one, stands out as something that's near and dear to my heart. And so I wanted to sort of just say to you, okay, what are you guys up to that you can share with the public?
Well, I guess I'll just step back to say that innovation is something that our court, as you've pointed out, is very interested in and has been very interested in for a long time. And the former chief of our court, Chief Judge Crabtree, spent a considerable amount of time, as did those who preceded him, in terms of engaging with the community to identify the needs of particular communities and how to better serve those communities. And as a consequence of the work of Chief Judge Crabtree, Chief Judge Stansfield, and others before them, there was the development, for example, of the Downtown Community Court, the Drug Treatment Court, our Indigenous courts, to better serve the needs of people in the province. We've also worked over the last several years to move our Justice Center in to a place where we were actually having remote courts and remote hearings on the weekend for bail matters. I must say that in the last year, we cooperated greatly and turned that registry, or turned the Justice Center, into a virtual registry that Court Services branch now staffed. And as a consequence, it's a virtual registry. And in cooperation with Court Services and many other stakeholders, including Crown, Police, Duty Council, Defense Council, we developed a weekend bail model that now is one where individuals who are arrested and face charges come before a court that is staffed by a judicial justice. There's a court clerk there, and the Crown is present, and Duty Council is available for all of those hearings. That changed, Dom, when we moved to the creation of those courts on the weekends, because we were then able to provide a specific time where Duty Council could provide assistance. And that is a significant, I would say, improvement in terms of access to justice for people who are facing criminal proceedings on the weekends. We also learned quite a lot about remote hearings over the years, and we have been working cooperatively with Court Services branch to ensure that we were beginning to install video cameras in as many places as we could across the province. We're still working on that, and that's still one of the pieces that we're continuing to develop as we move through how we're managing our criminal bail proceedings using a combination of video and audio technology since COVID has hit in our court locations. we moved fairly quickly to a hub model where we had 7 courts and 6 courts that served the province, where we co-located virtually our family courts and our criminal courts, and provided hearings on urgent matters for family matters, child protection matters, and as well managed our bail matters. And as I've indicated to you, we've begun to reintroduce a number of our other work that doesn't require physical attendance to get ourselves in a place to begin to open up some courts. We're working on working with a government to enhance our bandwidth, our technology, to improve our ability to provide hearings, virtual hearings as we move forward, to ensure that we're providing hearings, stable audio hearings where that is available as well. One of the things I think that we've learned through this process is that we are able to maintain at least an urgent level of service using different forms of technology that did provide the public with access when they needed it most to our court. And one of the things that we've discovered is that the way in which when we closed our registries, we needed to provide access to the public because they weren't virtually attending to those registries. The courts weren't closed, but the registry was closed. And we opened up email filing and telephone contact to ensure that people who would not have access to secure faxes, and many people don't, and certainly self-represented litigants would be able to access our courts in a way in which it was open to them to get there. And so we've done that. We're continuing to work with government to expand e-filing. And just to illustrate the difference, really, emailing documents, it still needs to go to a clerk who will then input that information and scan the information into the relevant files. E-filing directs that information directly into the keys, which is the computer system for civil matters. So it slides in directly. Fortunately for us, through the work of both people internal to the OCJ and Associate Chief Judge Wishart, we've been able to work with Court Services Branch to be able to scan in all of the file materials into our civil and family files, so that judges, through our scheduling system, were actually able to access the file materials and work remotely. And so that's been a great benefit to us, and another example of innovation using tools that we had to be able to enable us to be informed about the pleadings and proceedings because they were available to judges remotely. In addition to that, we have continuing to work, as I say, to increase our bandwidth, to increase the stability of those networks. We're also trying to we're working with government to expand the use of the JACs and the Family Justice Access Centers. I do want to say that they are all open and receiving clients virtually. And that's something I think that is very important for people in British Columbia to know, is that the Justice Access Centers are open, and also that they should, if they need those services, get in touch with them, and they will meet virtually either by telephone or other electronic means to access services. We're looking to expand that. As you know, we have a project in Victoria, our Victoria Early Resolution Project, where family litigants, before filing pleadings, go to a Justice Access Center. They work with the Justice Access Center workers, justice worker, family justice worker, to assist them in filling out any forms that they may have. They address what issues could possibly be mediated, sometimes in an asynchronous fashion, with the other party involved, and they also get the parties ready with their documents in order to ensure that when they come to court, they can actually come and have a meaningful court experience by going to a family a management conference and meeting, having an appearance in front of a judge, and the judge has the authority to pronounce an interim order on issues relating to, for example, child support and parenting time. And because the parties come with their documents, the judge has the information that they need to do that. We've actually seen just in early statistics around that, that a number of parties are able to resolve a number of their issues before even coming to court through the Justice Access Centers. So again, we're looking to expand those and to expand that project to provide greater assistance upfront to families before they come to court, and help them resolve some of their legal issues, and also be able to provide, I guess, hearings to be able to facilitate hearings because they're ready for those. And we're working also on how we provide access to duty counsel. There are some complexities, of course, around that. We have on our website put the information for duty counsel numbers to call for various assistance or help that may be required by individuals before they're coming. And we're continuing to work to develop ways in which virtually duty counsel can access the documents that people have so that they can provide them with the information and legal advice that they require when they come to court. So we're doing a lot of work behind the scenes to try to assist families in having more timely access to justice. We're also working with government to develop a way to manage applications to address child support and spousal support as a result of COVID-19 factors. And so that is in the works as well at the moment to see if we can provide quicker access to courts to address some of those issues. And we are certainly exploring all kinds of different technology to assist us in terms of how we can facilitate appearances too.
It's like allowing the public to hear all these things, not just the technology side to the solution is actually it's been wonderful just listening to you, Chief Judge. Let me ask you, you mentioned asynchronous. Has there been any thought given to hosting sort of hearings, whether they're the early conferences or the hearings themselves, other than the traditional court times?
Sorry, and I'm not sure if I exactly understand. Do you mean having hearings
outside of the court times? Because, you know, using virtual hearings and conferences. Given the population, there's a portion of the population who have day jobs and so on.
We continue to you know, sort of explore what it is that we can do to provide increased access. I think we do struggle somewhat in terms of operating outside of court hours because it's not just judicial officers, but it's a number of other people who provide support, whether it's a virtual hearing. Court clerks are required, and they too have other commitments as well with family and children and those sorts of issues. But I think what we're trying to do is to move to systems where we can provide greater assistance up front, so that when people come to court, they're able to have a meaningful court appearance rather than coming back to court on a number of different occasions. And we're certainly open to and exploring how we can manage court appearances sometimes that are required to schedule other things in different ways so that we can accommodate people's busy schedules. So we're trying to be flexible. One of the things that COVID-19 does, as I indicated at the outset, is we have to be mindful of the number of people that we're bringing to court, and we need to to reduce that number greatly so that we keep people safe when they come to courts and are able to enforce physical distancing. Every difficult situation has silver linings, and one of the pieces about that is it's causing us to look at other ways in which we can accommodate people attending, either through telephone or video appearances, to adjourn matters to other times and to have an appearance in front of the court, but maybe not physically be there, so that they can get ready for an appearance, either a virtual appearance or an in-person appearance when that will be a meaningful court event. And one of the things that we are looking at and struggling a bit with is how we link people up with those duty counsel resources, as I indicated, because one of the advantages of coming to court, it certainly takes people away from their day-to-day life when they come to court, but it is a place where you can meet up with a number of the resources that are co-located at courts, including accessing duty counsel and providing documents. And for people who have technological challenges, uploading documents and emailing them isn't that easy. So there are some services in the community that can help people, and I certainly know that you provide a lot of assistance to people in terms of filling out forms, for example, and documents to come to court. And there are other places where people can access assistance to help them make different kinds of appearances. And as I had indicated, we're not just looking at video appearances, we're open to telephone appearances as well. A virtual court doesn't exclude an audio conference. In fact, for many, it's the most accessible means of coming to court. So we are incorporating different means of low tech, no tech, high tech to provide access, and trying to work within those corridors to make sure that we link people up with duty counsel to assist them and provide them with that assistance, depending upon whether it's low tech, high tech, or no tech, and what that might look like. So we're committed to, I think, expanding the way we manage things.
Well, what we're finding, and this leads me to my next question about technology, and it shouldn't be a hurdle, but it is. We're finding, at least in our world, a cocktail of high tech, low tech, and no tech seems to work the best, except for, I guess, one group of people that we assist a lot. And internally at AC, we've been planning, because we recognize that they're out there, the victims of gendered violence. They are out there, but they're not there. We're not seeing them come in more than what we would think pre-COVID, because they can't get out. And arranging those phone calls, even just to do an intake, because they live in the same household as their abusive partner, is super challenging. When the time comes that they have to appear before your courts, can you just sort of address this and speak to the victims of gender violence and sort of let them know the things that you've kind of are thinking of in terms of how you're making sort of accommodations? Because it's certainly something that we do, is we try to identify those who are victims of gender violence early on, and we provide a set of services that's designed specifically for them. Any thoughts on that?
Well, I just want to say that our court has been open for urgent hearings, and that has included telephone hearings. We have, I think over this process, we recognized that it would be impossible for people to file affidavit materials, for example, in that situation. And we relaxed our requirements around that by permitting people to telephone and really fill out an application with the assistance of court services using a telephone, and then a judge would make a ruling on whether or not the matter was urgent. And if they determined it was urgent, most of those hearings proceeded right after that, if it was at all possible to do that. And there was, judges used inventive ways to obtain evidence from the complainant in the course of that hearing. So I think just even doing that, Dom has provided incredibly, has closed the distance in terms of the availability of service to individuals who find themselves at it's difficult for them to come to court. And of course, COVID made it difficult for everyone to come to court, but this bridged the gap for a number of people who would otherwise have had a very hard time coming. And so we have provided that, and we continue to provide that during this period of time. And we are, I think, attempting to provide services to individuals in British Columbia in new and innovative ways so that they are able to access justice during this difficult period of time. And as we do that, we learn a lot about the experience of those individuals in getting to court generally. And also moving forward, I think it's important to note that the justice system that existed at the beginning of March will be forever impacted by what is occurring as a result of the worldwide pandemic. And I think it's important to remember that there will be changes to our system that will be enduring and that will, I think, assist our court in improving access to justice for a number of people in British Columbia. And we're mindful of that.
Now, you've mentioned it a couple of times, Chief Judge. Urgent and non-urgent matters. And I certainly think that our listeners appreciate that a huge part of that may have been just sort of the courts having to decide who gets to be heard first because of emergencies. But for the average self-rep, as you know, their case is the most important thing in their lives. Moving forward, do you see the dissipation of that urgent, non-urgent classification, or will this still be with us for some period of time?
Well, I think, Dom, as we move through this process, we are attempting to recover a lot of the work that we lost as a result of rolling adjournments, and of course invited people to make application on even those matters if they were of the view that they were urgent and needed immediate attention, and many people did. We had to limit our ability to serve people to urgent matters because of the emergent nature of the pandemic. You will certainly recall that that week ending on March 13th was an unprecedented week where we witnessed closures of things we thought we would never see close at rapid pace. And by the Saturday, I think that was March 14th, the world as we knew it seemed to have changed irrevocably. And we jumped in very quickly into action, recognizing, for example, on our family case conferences and small claims conferences and child protection conferences, that we couldn't bring together people in that small an environment around a table safely. And then we began to analyze pretty quickly the rest of the work that we were doing and move with quite a bit of speed and pace to close down everything but our most urgent proceedings to keep really the public safe, but to provide access to courts for people who were dealing with urgent issues. As we're recovering that work, we are opening more and more matters up. We're able to resolve quite a few things through the use of case conferencing and able to case manage and reduce the amount of time, at least, that it will take for these cases to be heard in court. The fact that we've dedicated quite a bit more time, really almost double the time to those case conferences, I think demonstrates our interest and desire in helping parties resolve matters where possible and narrow issues, and also determine how those hearings could be heard, and not just necessarily by video, but also by audio. We're still managing things somewhat on an urgent basis on the footing that there are still more matters that require court time than we have available court time, whether it's urgent, emergent. we have to manage that, recognizing that we are getting a better handle on how it is we are going to provide trials, audio trials, video trials, or in-person matters. So it's here for a while, but we are also working on a parallel track to open up and to provide greater access so that we are able to serve the needs of people in British Columbia on the matters that, while not meeting the legal definition of urgency, are meeting the definition of priority in their lives.
Thank you for clarifying that. I mean, sustainability given reduced ability to provide the same level of service with sort of physical distancing rules certainly has made it complicated. And I'm glad you had the opportunity to explain to our listeners why you had to go about deciding why the urgents had to be heard first. This leads me to my final question, Chief Judge. You are the People's Court. Undeniably, though, lawyers are still seen by those who represent themselves as very powerful insiders. Through their regulators and bar associations, they, in their mind, when that relation exists for them, there really isn't an association of self-represented people. And for an individual who wants to have an opportunity to reach out and to connect with your courts, how do they do this? How can they get it done? If they have particular concerns, who do they reach out to?
Well, I think our court has always been very open and accessible in terms of issues that are brought to our attention, letters that are sent. We're responsive to those. We also, I think, answer or attempt to answer a lot of questions on our public-facing website. And I think it's really important that people go to our website as a source of information before they think about whether or not we're serving their needs, because there is a lot of very good information on there. I think for a moment, for example, we've got a small claims guide, there's a media guide, there's a guide to disputing a traffic ticket. There's information about, as I'd indicated earlier, what to expect in a audio hearing, what to expect when you're coming to court during these periods of time, how to wait to introduce yourself and give each other turns in terms of giving your evidence. But there's also a lot of other information that links people to different service providers in the community. And so I think it is very important that people know and access that as a source of information. I will also say that our court has held multiple town halls. I know you know that, Dom. You're always a big supporter. And last year, for example, we held a Twitter town hall where the provincial court hosted Chief Justice Bowman and Jennifer Mueller, a former self-represented litigant, in the Twitter town hall that was all really focused on access to justice and providing access. I do occupy a seat on our A2J, or Access to Justice Committee for British Columbia, working with a number of others to ensure that we are continuing to focus on the needs of litigants in British Columbia who may not have the assistance of lawyers when they come to court. And many of our processes are designed to facilitate self-represented litigants in terms of our small claims matters. And also, if you look at our new family rules that were out for consultation a short while ago, those also focus on using approaching subjects in terms of applications in a more accessible way, using more accessible language. We try to use plain language in our court documents, and our communications guru, retired, and Routhwaite certainly provides us with a lot of assistance in that regard, but also in terms of the articles that she writes about access to justice issues, and others who assist her on our public-facing website. I do speak regularly at a number of functions where the public attend. Our court does make every effort to be as accessible as we can, and we continue, as I say, even in publishing the most recent Microsoft Teams guide, work to make that as accessible as possible for self-represented litigants. And I have been in discussions with Carrie Simmons from the Canadian Bar Association, and she and I are also working together to see what it is that we can do to assist self-represented litigants through the technology process, if not if, but when we are able to roll out our virtual case conferences and virtual hearings, so that we can really assist people who do have access to that technology in feeling comfortable appearing that way before a court. I guess it probably also goes without saying that the more we're able to offer options for virtual attendance in terms of our case conferences, whether it's by telephone or by video, or using telephone or video conferencing in some of our trial matters, we are also, as we open up our courts, being, hoping to provide some access as well for in-person hearings for those for whom the other areas provide impermissible barriers really to access to justice. So we recognize that we need to deliver services in many different ways to meet the needs of the public. And I can also say that we've done a lot of work with court services over the last number of years to work towards the development of the online translation service that we now have as well, so that there is a translation that is available, or interpretation translation that's available in the context of these proceedings from an online source as well. So we've done a lot of work in the last 8 weeks at a tremendous pace to respond to this unprecedented crisis, but we had done a lot of work before as well to provide access to justice for individuals across the province. And it's the combination of those two pieces that are giving us a platform to get through this. It's sometimes a bit bumpy. We appreciate people's patience as we struggle with some of the technology issues. We continue to be very hopeful that there will be further investment in technology for the justice sector in this province. There has been some underinvestment in the past that has resulted in some of the issues that we're presently facing now in terms of the strength of the technological response we can provide, and we are working hard to catch up. But there's no lack of commitment on the part of our court and our judges and our judicial justices, our case managers, court services in terms of the court clerks to provide access to justice in a meaningful way to the people of British Columbia. So what we're lacking in tools at the moment, we're trying to make up in terms of enthusiasm to continue to ensure that we're providing access in a meaningful way.
Well, Chief Judge Gillespie, thank you very much. I certainly appreciate the hard work of you and your staff. Previous to this, of course, I hear it because I talk to you, but for our listeners to find comfort in hearing from you, the empathy you displayed, and like I said, the words are one thing, but one really needs to look at your website to see just how much work has gone on for each one. I wanted to wish you well. Please extend my heartfelt thanks to your colleagues, and everybody else that make the People's Court the People's Court.
Thank you, Dom. I appreciate it. And I would also be remiss, I've thanked everybody, but I will say very much that we have a very supportive team at our provincial court. Our two legal officers as well, Caroline Berkey and Karen Leung, are fantastic. And all of the judges, the associate chief judges. And I will also say that people who have been coming to our courts have also been very willing to engage in the whatever way that we have provided so that they can access justice, and have shown a resiliency and capacity to work with the technology in any way that they can. So I'm grateful to everybody for their willingness to do that. And we will continue to do what we can to provide as great access as possible in these challenging times, and to constantly review what it is that we're doing to ensure that we're meeting the needs of people in BC as the grounds are constantly shifting for us in this worldwide pandemic. Dom, thanks for all the work you're doing as well. I appreciate it. And I appreciate you taking the time to meet with me today. It's fantastic.
Well, I wish you well, Chief Judge Gillespie.
You too, Dom. Thank you very much.
Bye-bye now. Take care.
Bye-bye. You too.